Let us start solving the questions of Indian Evidence Act 1872. First of all, read the quotation. जिंदगी में हार तब नहीं होती जब आप हारती हैं, हार तो तब होती है जब आप हार मान लेती हैं। यानी वही बात, मन के हारे हार है, मन के जीते जीत। When we mentally prepare that I can do, I can win the race, I can achieve the target, the goal, then a little unsuccess, failure, these are immaterial once you win the race. Yes, start the first question. A dying declaration under section 32. A dying declaration under section 32 of the Evidence Act is admissible in evidence. Is admissible in evidence. A dying declaration under section 32 of the Evidence Act is admissible in evidence. See the option. When, only when it is reduced in writing. No. Actually, dying declaration may be in writing or oral. Only the term only is not correct. So it is incorrect. Next, only when it is made to police officer, it is also wrong. Only when it is made to a magistrate, no, it is also wrong, because dying declaration can be made before any person, whether magistrate, he is a magistrate, police officer or other authority. So it is also wrong. Only when it is made in immediate presence, no. All the options are wrong. So the first question is not correct. Okay? Yes. Next. A dying declaration to be admissible under Indian Evidence Act must be made before magistrate, yes, police officer, yes, doctor or private person, yes, but it should be in joint. So option D, magistrate, police officer, doctor or private person. This is the correct answer. So if any dying declaration, if a statement, that person after making such a statement is dead and the statement is given before magistrate, police officer, doctor or private person, such a statement shall be dying declaration. It means dying declaration may be given, may be made before these persons, before these authorities. So the correct answer of the question is D. D is the correct answer. Next, the form of dying declaration is material, immaterial, must be in writing, no, made be orally spoken, no. These are wrong, but here material or immaterial, It is very clear, it is very obvious. Dying declaration actually, on the basis of it, a person cannot be convicted except the circumstances is consistent to the statement, to the incident or accidents. Unless it is not consistent, dying declaration cannot be relevant. It means, relevant means, on the basis of dying declaration, a person cannot be convicted. So, dying declaration is an immaterial evidence. The option A is correct of the question. Okay? Only on the basis. Always the person accused cannot be convicted. Only on the basis of dying declaration. So the correct answer of the question shall be A. A. Dying declaration can be the basis of conviction. Can be basis of the conviction. Reason: dying declaration can be the basis of conviction. Dying declaration must be made with expectation of death. No, it is accepted in England, English law. In India, it is not accepted. It is not admissible. So this is wrong. And dying declaration can be made the basis of conviction. Yes, can be made. It means on the basis of dying declaration, a person accused may be convicted. Not shall be convicted, may be convicted. So, on the basis of sole dying declaration, a person accused may not be convicted. It means only on the basis of. So it depends upon the circumstances. So the first is can be convicted. It means the person accused may be convicted and may not be convicted. There is option. So this statement, the statement that is R is true. Assertion is true, but reason is wrong. C. A is true, but R is false. Person accused may be convicted and may not be convicted only on the basis of the dying declaration. So R, it means A is correct. This is A and it is R. C option is correct answer. Okay. Next. A dying declaration cannot form the sole basis of conviction unless corroborated. Sole basis of the cannot form sole basis. Sometimes it may be sole basis of conviction. Only on the basis of dying declaration a person accused may be convicted. It means it may be the sole basis of conviction sometimes. So it is not correct. Is a weak kind of evidence on the basis of dying declaration a person accused may be convicted. It is not completely weak evidence, because if it is a weak evidence, then the person accused cannot be convicted on the basis of, only on the basis of dying declaration. So it is not in totally a weak evidence. It stands on same footing as any other place of evidence. Yes, it is just like other evidences. So third is correct. And has to subjected to a very close scrutiny for reliability. Yes. So the third, fourth option is correct. Here C is correct option. A dying declaration is admissible in evidence. A dying declaration is admissible in evidence. Yes. Its admissibility is founded upon the principle of necessity. Yes. A is correct and the reason is also correct. Reason is also correct. So the correct answer A. Which of the following statement can be converted into dying declaration after the death of person making it? After the death of person making it. Yes. FIR registered by such person. Yes. Statement of such person recorded under section 164 CRPC. It is also dying declaration if the person making the statement later on he dies. Then such statement shall be regarded as a dying declaration. Statement given by such person to executive magistrate. So all the above, this is the correct answer of the question. This is the correct answer of the question. Yes. Under section 32 class 1st Evidence Act, statement made by whom of these are relevant? Persons who are dead. Yes, according to section 32 class 1st. Persons who are dead, person making the statement and he dies. Persons who are incapable of giving evidence. Yes. Persons whose attendance cannot be procured without delay or expenses. Yes. All of these. Yes. This is the correct answer. This is the correct answer of the question. D. Option D is correct answer of the question. Because all these persons if make any statement and later on these conditions if they suffer, such statement shall be regarded as a dying declaration. Such statement shall be regarded as a dying declaration. Yes. The question before the court, is the cause of wreck of a ship. This is the question. How the ship is wrecked? This is a question. How the ship is wrecked? Protest made by the captain, whose attendance cannot be produced, is not relevant fact if the captain is not present before the court. His statement will relevant or not. Whatever statement he is giving in protest, students, is not relevant fact. No. Whether he is not present in the court, he is unable to present in the court. According to the section 32, if he cannot present without more expenses, he cannot arrive timely, it means on the basis of his statement, on the basis of these circumstances, his statement shall be regarded as a dying declaration. And dying declaration, if any statement is regarded, it means that statement shall be a relevant. That statement shall be regarded as a relevant evidence, relevant fact. So is a relevant fact whether the captain is not present in the court. Whether the captain is not present in the court at, his statement shall be regarded as a relevant fact. Next question. Provisions section 32 clause 1st of Evidence Act are attracted where and what is not true. Where and what is not true. The cause of death is required to be ascertained. Yes, it is true. The deceased statement is related to the cause of death. Yes. To circumstances connected with death. Yes. But verbal statement is not admissible. It is wrong. So the option D is incorrect. It's false. The statement, the option D is false. Dying declaration in the form of first information report written by police officer without obtaining the certificate of mental fitness of the victim, though a person giving the statement mental certificate. Without mental certificate. His statement, whether this statement is regarded an FIR, this is the question. In the case of Dalveer Singh versus State of Punjab, in the case of Dalveer Singh versus State of Punjab, versus State of Punjab, the Supreme Court decided that without mental certificate, if any statement is given before the magistrate, such statement shall be regarded as an FIR. Such statement shall be regarded as an FIR. And if any FIR is lodged without mental certificate and the person lodging the FIR later on dies, such FIR shall be regarded as a dying declaration. So it can be admitted, it shall be treated as a dying declaration. Yes. Option C is correct answer. A, first of all, read the options. The first option, cannot be treated as a dying declaration, wrong. Cannot read in evidence, it is also wrong. I have told you, in the case of Dalveer Singh versus the State of Punjab, it was decided by the Supreme Court that FIR may be lodged without mental certificate, and if a person lodging the FIR without mental certificate before the police officer and later on he dies, such FIR shall be treated as a dying declaration. And if the statement, if the FIR is treated as a dying declaration, it means shall be relevant. So the correct answer, can be treated as a dying declaration. This is the correct answer. Yes. Which of the following statements hold true for dying declaration? Which of the following statements hold true for dying declaration? It means for dying declaration, which statement is true? Dying declaration cannot be used as a sole conviction. It means only on the basis of dying declaration is a person accused convicted. Can a person accused convicted? Yes, he may be convicted. First of all, read the options. The dying declaration cannot be used as a sole conviction. Dying declaration, unless corroborated, cannot be used as the basis of conviction. Dying declaration, which is brief, must be discarded when eyewitness affirms that the deceased was not in a fit state to make the declaration. If eyewitness affirms what? The deceased was not in a fit state to make the declaration. What declaration? Dying declaration. The medical opinion cannot prevail. It means doctor's report shall not prevail. This is the correct answer. Yes, among of them, option D is the correct answer. Most appropriate answer. Most appropriate answer. Okay? So D is the correct answer. Next question. A dying declaration to be relevant must be made before a magistrate, must be made before a police officer, may be made before a doctor or a private person, may be made either before a magistrate or police officer or a private person. This is the correct answer. It means option D is the correct answer of the question, appropriate answer. Or you can say the complete answer, because all of them A, B, C is